Good afternoon, folks. We're letting people into the waiting room and we're going to get started in about a minute. We're going to wait about another 30 seconds, folks, and then we're going to get started. I can see that people are still coming in through the waiting room. Okay. So, good afternoon, everyone, and thank you for joining today's webinar on Medicaid Personal Care Assistant, or PCA Services, Part 2. This webinar will focus on explaining how to challenge an adverse benefit determination, meaning a denial, reduction, or termination of PCA benefits. We presented part 1 of this series, an overview of PCA services, last week, and the webinar and other self-advocacy materials are available on our website. Next slide. My name is Gwen Orlowski, and I'll be presenting today along with Regina Smith. Regina is the supervising attorney in our children and youth practice group. Next slide. Disability Rights New Jersey is a nonprofit organization. We are designated under federal law as the state's protection and advocacy agency for individuals with disabilities. Next slide, please. A shout out to the New Jersey Council on Developmental Disabilities. Thank you, Council. They provided some funding that helped make this webinar series possible. Next slide, please. Before we get started, a few housekeeping items. This webinar is being recorded, and both the slides and the recording will be shared with all attendees afterward, and they will also be available on our website. Your audio and video are muted, but you can use the chat feature to submit questions or comments at any time. We left time at the end to do Q&A based upon the questions entered into the chat during the webinar. If you need subtitles, you can turn them on by clicking More and selecting Show Subtitles. And if you have any accessibility concerns, please reach out in the chat box, and disability rights staff are on hand to problem solve. Next slide. I note that the information provided today is for general informational purposes only and does not constitute legal advice. This session does not create an attorney-client relationship, and no promise or warranty is made about outcomes in any specific case. Next slide, please. Here are today's learning objectives. You can take a look at this slide. One quick note. This area of Medicaid law is very heavy with acronyms, and we do our best to say the entire phrase each time along with the acronym. The exception to the general rule is we will use PCA in place of personal care assistant. Next slide. We'll begin today with a quick recap of PCA services basics. And again, if you missed part 1 of this series, you can view the webinar on our website, and the link is in this slide. Next slide, please. Personal care assistance is what is called a state plan service rather than a Medicaid waiver service. This means that PCA services are available to all Medicaid recipients, both children and adults, subject to a medical necessity standard. You don't have to be on a waiver like Managed Long-Term Services and Supports or MLTSS or one of the DDD waivers. PCA services are medically necessary, health-related tasks associated with queuing, supervision, and/or completion of the activities of daily living, things like dressing, bathing, ambulation, or transfer, as well as instrumental activities of daily living, things like housekeeping, meal prep, and shopping. In order to be eligible for personal care assistance services, a Medicaid beneficiary must meet the eligibility criteria: either moderate or greater hands-on assistance in one activity of daily living, or minimal assistance or greater in three activities of daily living, one of which must require hands-on assistance. Both eligibility and the number of hours received are determined by a beneficiary's managed care organization, or MCO, for example, WellPoint or Horizon NJ Health, using a state-developed PCA assessment tool. PCA services can be delivered through an approved provider agency like a home health agency, or by self-direction through the Personal Preference Program, or PPP. And note, there are slightly different rules for children and youth under the age of 21, and you can learn more about that by watching part 1 of the webinar of this series. Next slide, please. A word here about personal care assistance and care management. The New Jersey Medicaid MCO contract requires that managed care organizations provide care management to all beneficiaries who would benefit from care management services. And for people on MLTSS, the managed care organization must provide care management. Care management connects a Medicaid beneficiary with a care manager, who could be a nurse, a social worker, a physician, or another professional. And care management is defined in the contract as a comprehensive, holistic, dynamic process that encompasses the 7 components you can see on this slide. Medicaid beneficiaries who use PCA, and this is true also of private duty nursing, could well benefit from care management services. And we're going to be talking about the law relevant to appeals in a moment, but I'm going to mention here one of those laws. The State Medicaid Agency, the Division of Medical Assistance and Health Services, or DMAS, issued a memo about utilization management for ongoing services on May 22nd, 2025. We're going to call that the UM memo in this webinar. And that memo says some important things about PCA and care management. First, the Medicaid agency said in that memo that it has become aware of people receiving PCA and private duty nursing with reductions or terminations who do not appear to be receiving care management, even though changes to PCA services may impact those individuals' health status and care needs, underscoring the importance of access to care management. In order to address this issue, DMAS now requires that both the initial notification letters and approvals for PCA services and notices about adverse determinations like reductions and terminations must include the following. First, information about the availability of care management and how it can help people navigate changes to PCA services. And second, contact information for the MCO's care management team. Alternatively, if the individual already has a care manager, then contact information for the beneficiary's care manager should be in the letter. Next slide. We're going to talk now about the 14th Amendment, due process, and a brief legal overview. Next slide. So why do we include this slide, which is heavy with law? The United States Constitution, a United States Supreme Court decision, reference to federal and state regulation, and other law. We do this because the law that underpins a Medicaid beneficiary's right to due process is so important. It's rooted in the 14th Amendment of the United States Constitution. These rights are not to be taken lightly, not by the state Medicaid agency or managed care organizations or administrative law judges. Here's what the 14th Amendment says that's relevant to Medicaid and PCA services. Quote, nor shall any state deprive any person of life, liberty, or property without due process of law. The 1970 case Goldberg versus Kelly, the Supreme Court decided that welfare benefits like Medicaid are statutory entitlements, in other words, property, and that individuals receiving them were entitled to procedural due process prior to the termination of benefits. So, what is procedural due process? It's all the things we're about to discuss: written notice, a hearing before an impartial judge, a chance to present evidence, cross-examine, review records. All of this is baked into the constitutional rights of Medicaid recipients, and that's a big deal. Those due process protections the court talked about in Goldberg versus Kelly are embodied in the laws on this slide. At the bottom of the slide, we've highlighted that guidance that I mentioned from May of 2025, the one that the Medicaid agency directed to managed care organizations regarding utilization management. This memo highlights and puts meat on the bones of some of the due process requirements in the federal law. We're going to talk more about it throughout the webinar, and a link to where you can find this memo on our website is in this slide. Next slide. Due process rights are rooted in state actions that are adverse to a Medicaid beneficiary. When those actions are taken by a managed care organization or MCO acting on behalf of the state Medicaid agency, those actions are called adverse benefit determinations. Next slide. A federal regulation defines an adverse benefit determination to include the following: a denial or limited authorization of a requested service, a reduction, suspension, or termination of a previously authorized service. Quick note here, I've never seen a suspension of services in my 35+ year career, so we're not going to talk about those today. Next, a failure to provide services in a timely fashion. This is tricky because when we look at different sources of law, they say different things. For example, the managed care contract says that for routine determinations must be made and a notice of approval must be provided by telephone or in writing within 14 days of receipt of the necessary information to make an informed decision. The New Jersey regulation referenced also in the contract requires that it be done within 15 days of the receipt of the claim. And the federal regulations say that for standard authorization decisions must be made in a time frame not to exceed 14 calendar days after receiving the request for the service. That's all well and good, except that that regulation goes on and has a provision that reduces the 14 calendar days to 7 days as of January 1st, 2026, like a couple weeks ago. But honestly, we at Disability Rights New Jersey haven't seen that change take effect, and we're really not clear on when it's going to take effect. So for our purposes here, we say that for non-urgent PCA determinations, the managed care organization must make a decision and give a notice within 14 days. A quick note on urgent determinations, the time frame there is generally 24 hours with a cap of 72 hours. Next slide. So here are some examples of adverse benefit determinations. The first example, an MCO denies a Medicaid beneficiary PCA altogether, stating they do not need hands-on assistance in any activities of daily living. So this would be a denial. Our second example, a beneficiary meets with their doctor who writes a prescription based upon their opinion of medical necessity for 30 hours per week of PCA services, but the MCO only approves 25 hours a week. This would be a limited authorization. And our third example, after 5 years, an MCO reduces a Medicaid beneficiary's PCA services from 40 hours a week to 20 hours a week. This is a reduction. Next slide, please. Next, we'll turn our discussion to the written notices that must accompany MCO adverse benefit determinations. Under the federal regulations, these are called a notice of adverse benefit determination. However, the New Jersey MCO contract and the utilization memo, management memo we've refer to these as notices of action. And so for this webinar, we're going to refer to them as a notice of action. Next slide. In order to meet constitutional muster, a notice of action must be both timely and adequate. In order for a notice of action to be constitutionally adequate, it must contain the following information, and that information must be in plain language and in a manner that is accessible, both to people with limited English proficiency and to people with disabilities. Here's what needs to be included. A statement of what action the managed care organization intends to take and the effective date. A clear statement of specific reasons supporting the intended action, the regulation that supports the action, an explanation of the beneficiary's appeal rights, first to the level 1 managed care organization intern appeal, a level that must be exhausted first before someone can move to the second level, which would be a Medicaid state fair hearing, and the process to request an expedited appeal. The notice also has to include the circumstances under which PCA services continue if an appeal is requested by the Medicaid beneficiary. This is called continuation of benefits, or COB, and the notice must also explain the potential to pay back these services if the appeal is lost. Footnote there, I've also never seen anybody have to pay services back, so don't be afraid by that notice. One of the biggest complaints we hear here at Disability Rights New Jersey is that people do not have a copy of the PCA assessment when they receive a notice of action. Our legal opinion is that inclusion of the PCA assessment tool is one way to meet the requirement to provide a clear statement of the specific reason supporting the intended action. And without a copy of the assessment attached, the written explanation would need to be so detailed and voluminous that it would just be easier to include the assessment. While we have case law that supports this, we have not convinced the state Medicaid agency, and so for now, MCOs do not include the assessment tool with the notice of action. Next slide. The notice of action must also be timely, and it's important to note that timeliness depends on whether the action is an initial action for a requested service or an action in response to a reassessment for ongoing PCA services, like a reassessment after a changing condition. In the first instance, when the MCO is making the initial decision on a request for PCA services, there's confusion in the law, which I already mentioned, because the federal regulations appear to have a change effective January 1st of this year. For our purposes here, we'll say that the written notice for denials or limited authorizations must be sent to the Medicaid beneficiary no later than 14 days after receiving, I'm still one slide back, please, after receiving the request for services, or as the contract says, receipt of the necessary information sufficient to make an informed decision. The star was on that slide because the federal law says that 14 days was reduced to 7 days effective January 1st, 2026. Stay tuned on that. And again, I mentioned the time frame for urgent determinations is generally between 24 hours and not more than 72 hours. For terminations or reductions of previously authorized PCA services, the MCO must mail the notice of action at least 10 days before the date of the action. There's a couple of exceptions to that 10-day requirement, for example, in cases of fraud, which we won't go into here. I believe that we should stay on the slide that we're on now, the example, so please do not switch the slide. So we see a lot of notices of action that are constitutionally defective or otherwise problematic. And since bad notices affect the rights of Medicaid beneficiaries, this is an issue we spend a lot of time working on. And we believe our advocacy efforts have been successful on some level. We see the May 2025 memo, which we discussed in detail in this webinar, as DMAS's response and attempt to get compliance from MCOs in drafting these notices. So here are some examples. I think we're actually on the incorrect slide. So can we go forward one slide, please? Okay, go forward one more slide. Okay, one more slide. One more slide. Okay, typical problems with notices of action. Thank you. We're in the right place. So here are some examples. A limited authorization is not reflected on the approval notice. Why does this matter? It matters because if somebody requested 40 hours, but was only approved for 30 hours, and it's treated as an approval as opposed to a limited authorization, they might not receive the proper notice of action with all of the rights we just talked about, and most importantly, information about how to request the internal appeal and the right to a Medicaid fair hearing upon exhaustion. A second example, the action is characterized as a denial, but it's really a termination. Why does this matter? It matters because the right to continuation of benefits only applies to reductions and terminations. And by mischaracterizing the action on the notice as a denial, the beneficiary may not understand the right to continuation of benefits, and they may miss their opportunity to request them. Our third example, the reason given for the adverse action in the notice is boilerplate or thin or misstates the eligibility rules. Why does this matter? This matters because the Constitution requires that the notice provide clear and specific reasons for the action. Boilerplate can never be specific to the person. It's really a cut and paste exercise. An example of a thin explanation that I've seen is you don't need hands-on assistance with bathing because you don't need hands-on assistance with bathing. It's, circular, especially for a person who was previously found to need hands-on assistance. And sometimes we see the law just misstated incorrectly. The next example, a notice refers to an external independent review process. And why is this problematic? This is problematic because individuals receiving personal care assistance do not have an option to go to the external independent review process, sometimes referred to by the initials IURO. For example, if it's a private duty nursing case, you do have that option, but not for PCA, and so that should never be included in the notice. And the last one, which is probably one we hear most commonly, is that the individual received the notice of action long after the date on the letter. This is most problematic in reduction and termination cases where a beneficiary has a right to continuation of benefits, because typically one only has 7 days to request the continuation of benefits, and a delayed notice can mean the time frame for requesting the continuation of benefits is over. For this reason, it's very important to keep the envelope and check for a postmark on the envelope. This can help you make a case with DMAS for continuation of benefits outside of the 10-day window. There are legal avenues available to attorneys to challenge bad notices, and we do this frequently at Disability Rights New Jersey. But truthfully, these legal avenues are too complicated for people representing themselves. That doesn't mean there aren't any effective advocacy strategies for people representing themselves. So let's go to the next slide. Here is a useful advocacy tool from the May 2025 memo. In section 1 of the memo, DMAS identifies a problem. Notice of action letters failed to clearly explain the reason for the reduction or termination, and of particular concern were cases where there was no clear indication of a change in the member's condition to justify the change in the approved hours or units. And then DMAS proposes the solution. Notice of actions where PCA services are reduced or terminated must include a full detailed explanation of the reasons for the decision using the plainest language possible, and they cannot solely reference the PCA reassessment tool. Importantly, any reduction or termination due to a change in condition identified in the reassessment must be fully described. And there's even more helpful language in the memo itself that you guys can look at. And important to note, any notice of action that fails to do this will be considered non-compliant and incomplete and non-compliant. Disability Rights New Jersey has asked the Medicaid agency what they will do where a notice of action is non-compliant and how people can bring that matter to their attention. And we're still in conversations around these questions. For now, here's what we can tell you. In the next week or so, we will have a dedicated email address where people can send us incomplete and non-compliant notices. This will allow us to collect, redact, and share the notices with DMAS to systemically improve the system. Note, however, if you want our services, you still have to go through intake. This email will not be an intake email. Second, we will have a checklist resource available on our website with directions to complete and attach the checklist to your internal appeal request and fair hearing requests so that the defects in the notice will be part of the appeals process. And third, we hope to work with DMAS to get a way in which Medicaid beneficiaries who believe they received an incomplete and non-compliant notice can bring this directly to the attention of the Medicaid agency for redress. Stay tuned on that third prong. Next slide. The May 2025 memo also makes clear that the detailed explanations we just talked about must be also included in initial approvals, and we recommend you save any initial approvals for future comparison. Next slide. Before we talk about the internal appeal process and the Medicaid fair hearing process, I'd like to take a moment to talk about getting a copy of the PCA assessment tool as well as other relevant documents for the appeals process. Next slide. The federal regulations provide robust rights related to getting copies of all documents that may be relevant to both an internal appeal and a fair hearing, and you can see them here on the slide. The most important information on this slide is the earliest point in time that beneficiaries have a right to their case file and other relevant documents in the appeals process. That point of time is at the time the notice of action is issued. The notice must include information about requesting the case file and other documents free of charge, and those documents, once requested, must be provided sufficiently in advance of the resolution of the appeal to be meaningful. And so a practice tip, which I'm going to say several times over the course of the next couple slides, is always request the documents, especially the PCA assessment, by telephone and writing immediately upon getting the notice. Don't wait. Next slide. The memo helps in two regards regarding accessing documents. First, in section 1, it makes clear that a copy of the completed score assessment or reassessment must be provided within 5 calendar days of request, and that request can be by telephone or in writing. Second, in section 5, the Medicaid agency recognizes the problem where a beneficiary requests a fair hearing as well as additional information, but the managed care organization fails to provide the requested information or documentation until immediately before the hearing date, which makes it difficult for the person to effectively support their challenge on the MCO's adverse determination. The solution: now, Medicaid requires that when additional documentation is required from the MCO to support the beneficiary in the fair hearing, as a matter of fundamental fairness, and I would say constitutional law, the requested material should be mailed within 5 business days of the request. And I note that this provision is not specific to the internal appeals process, but it should be. Moving on to the next slide, the internal appeals process. I will note at the outset that the internal appeal rarely changes the outcome of an adverse benefit determination. But that doesn't mean they aren't useful and that you shouldn't take them seriously. Next slide. How do you initiate an MCO internal appeal? First of all, remember that the process to request the appeal, continuation of benefits, and begin requesting the case file and documents is laid out in the notice of action. Secondly, many times the MCO will offer an informal reconsideration period of the adverse benefit determination. And if you want to cooperate with that, fine, go ahead, especially if it's an easy to solve problem like a missing piece of information, maybe a doctor's prescription. But don't let that stop you from moving the formal process forward at the same time. These are two trains on parallel tracks, and they both need to move forward. In terms of requesting the internal appeal, you can do this in writing or orally or both. The time frame that you must do it within is 60 days of the date of the notice of action. However, if you want continuation of benefits, you must request the appeal and the continuation of benefits within 10 days of the date on the notice, or not later than the intended effective date of the action. Typically, the notice is dated 10 days before the date of the action, so you're good to always assume no more than 10 days. If you have more than 10 days because the action isn't happening for 15 days, all the better, but generally they're the same. Note, you have to request the continuation of benefits at the internal appeal level and again at the fair hearing level, and Regina will be discussing that more to keep them throughout the full appeals process. We also include a telephone number here for quality insurance. If you've requested continuation of benefits and you didn't get them, this is the number to call. And then there's some information about what managed care organizations must provide in this process. Next slide. Oh, also just another, because I can't say it enough. Remember, when you're requesting that appeal, request a copy of the case file as soon as possible, immediately when you're requesting the appeal. In the May 2025 UM memo, Medicaid recognized that there are problems with accessing the appeals process. The solution, MCOs now need to offer the option to file by phone, mail, fax, and a secure online portal. They had 6 months to implement this. I believe that's over now, but I'm not 100% sure. And again, I've included the bold reminder to request a copy of the case file as soon as possible. You can tell I feel very strongly about that. Next slide. So what is an internal appeal? Truth be told, the way they work in real life is pretty ineffective. People request the appeal. They frequently don't get their own file or even a copy of the assessment tool. They don't introduce any new evidence. Sometimes they do introduce a letter challenging the decision or a doctor's explanation, but nothing changes. But it doesn't have to be this way. The law gives you really significant rights, and we're encouraging you to use them. We've already talked about the right to the case file. I don't think I need to say it again, other than to say it has to be provided sufficiently in advance so that you can meaningfully use it in the internal appeals process. Secondly, you have the right to present evidence, testimony, make legal and factual arguments. And here's the real kicker. You have the right to do this in person and in writing. Most people don't know they have the right to do it in person, and I don't think that MCOs ever afford people an in-person hearing. But that's what the federal law says. The MCO also has to provide time information about the relevant time frames, which is 30 days, so this process can get moving and you can meaningfully participate. And the contract provides that if in person, it needs to be at a community location that's both convenient and accessible to the Medicaid beneficiary. So I think we're suggesting why not request an in-person internal appeal. Take advantage of the opportunity to meet face-to-face with decision makers, ask them questions, elicit testimony, introduce new evidence like doctor's notes or old assessments for comparison. Perhaps this could be a meaningful way to find a positive resolution. There are other rights that people have on this slide. I just want to highlight the last one. The decision maker has to be somebody who was not previously involved, has appropriate clinical expertise, and takes into consideration all the information submitted. You also have to have information about filing an expedited appeal. Next slide. What to expect regarding the resolution? I know Regina's going to go through some of this in her presentation, so I'm going to leave that to her. But for 2 points that I want to make in this slide. The first is, I already mentioned they have 30 days to resolve the appeal, and if they fail to do it in that 30 days, then that is considered an exhaustion of the internal appeal, and the Medicaid beneficiary can proceed to the fair hearing. And the second, I mentioned this before, but we've seen it, so I want to say it again. The written notice of resolution should not include the process to request an external independent review for personal care assistance services. It can for private and should for private duty nursing, but not for personal care services. There's no access to the IURO process. And Regina, with that, I turn it over to you.
Thank you, Gwen. Next slide. So let's talk together about that second level of the appeals process. Next slide. Once an enrollee receives a notice of appeal resolution, that's the letter Gwen just mentioned explaining that the MCO has upheld the adverse benefit determination, the next step is to request a Medicaid fair hearing. In our regulations or the MCO contract, Medicaid fair hearings can also be called state fair hearings or even Medicaid state fair hearings. They all mean the same thing. The notice from the MCO must explain how to properly request the fair hearing. Importantly, Medicaid members typically have 120 days to request the fair hearing, but there's a critical deadline buried inside that bigger window, the continuation of benefits deadline, or COB. If a member wants to continue their services while the appeal is pending, they must request the fair hearing within 10 calendar days of the date of the notice. So the rule is 120 days to appeal, but only 10 days to preserve continuation of benefits. When a fair hearing request is filed within that 10-day window, it functions like a stay. That's a pause. It pauses the reduction or termination while the appeal is pending, and that's grounded in our federal regulations and supported through our state regulations and the MCO contract. If you requested continuation of benefits when you submitted your internal appeal, please remember you will need to do it again when requesting the fair hearing. If you did not request continuation of benefits or file your internal appeal timely, you will not receive continuation of benefits while the fair hearing is pending. So in practice, Disability Rights New Jersey always tells families and beneficiaries, if you are thinking about challenging the reduction or termination, do not wait. Get the request in immediately by mail or fax and keep your proof of submission. Next slide. I wanted to share with you a sample of the fair hearing request form that is usually found at the end of the notice of appeal. The main goal here is to make sure that it's completed correctly and submitted fast enough to preserve a continuation of benefits. Even if your facts are not fully developed yet, this form is your way into the system. You can always submit supporting documents afterwards, but you cannot fix a missed continuation of benefits deadline once that 10-day passes. So included in this proper notice is your appeal rights. Please click. There's also bolded information about the timeline and continuation of benefits. There is a section on where to send the appeal. And I want to note that in this section, it also tells you to include all the pages of the notice you received. There is also a box to check for your continuation of PCA services. And finally, a space to indicate if you or a member of your support team require an interpreter. Once you submit this form by fax or mail, you will receive first a transmittal notice, and that will come from DMOS explaining that the agency sent your request to the Office of Administrative Law. After you get that, you will then receive a notice of hearing from the Office of Administrative Law. We will note that recently we have seen long delays in OAL scheduling of the fair hearings. So don't panic if you do not receive the notice of hearing right away. If you are looking for more information, you can call the Office of Administrative Law's main number, and they will give you information about the case. Next slide. The Medicaid fair hearing is presented before an administrative law judge through the Office of Administrative Law. This is a formal process, but it's available to Medicaid eligible beneficiaries to challenge those denials, reductions, suspensions, or terminations of services. Settlement discussions are common. Sometimes they occur before the hearing even starts, and sometimes during breaks while testimony is ongoing. Many hearings in PCA service appeals are held telephonically, but you can request an in-person hearing, especially if credibility, medical complexity, and accommodations warrant it. We encourage you to hold your fair hearings in person, or at the very least, virtually, so that you have a better understanding of who is present during the call and who's speaking to you. At the heart of this fair hearing process is something called due process. The hearing system must satisfy those requirements set out in Goldberg v. Kelly, the case that Gwen had talked about earlier. This is that U.S. Supreme Court case that entitles all Medicaid members to have a real opportunity to be heard before their benefits are taken away. Next slide. So let's talk about those due process rights. Due process rights include the timely and adequate notice, an opportunity to be heard in what we would consider a meaningful way, the right to present evidence, and the right to examine the member's file. The member must also be able to confront or cross-examine witnesses for the MCO. That means to ask questions to the MCO. We will talk about that a little bit later. And they have the right to retain an attorney or a representative. The decision in the appeal must be made by someone impartial to the case, and it must be based solely on the record in front of that administrative law judge. The record can include documents entered into evidence. It can include any testimony given on the record and include any opening or closing statements. That's what comprises the record. In some instances, a member might even qualify for an expedited hearing, and the MCO can provide you information on requesting that expedited hearing. Finally, all members have a right to a written decision after the fair hearing. So let's proceed to the fair hearing with the next slide and talk a little bit about the process. In court, generally, we follow something called the rules of evidence. It's what allows attorneys or individuals to present information to the judge. In the Office of Administrative Law, those rules are relaxed a little bit, but they still have a structure. Typically, you will have a witness list and exhibits. Again, exhibits are the documents that you want the ALJ to review and consider. And the MCO will have a witness list and an exhibit packet. You will exchange those documents and witness lists at least 5 days before the hearing. The MCO might also have expert witnesses. When we see the MCO bring experts to the fair hearing, we like to limit the scope of what their expertise is on, if at all possible. And this is usually true when an MCO is trying to use a general nurse reviewer to override your treating provider's specific medical assessment. As I mentioned earlier, you have the right to cross-examine the MCO witnesses. This gives you a chance to ask them questions related to the assessment tool, the decision to reduce, deny, or terminate, and anything that they might know or not know about the individual's need for personal care assistance. A huge practice point. Procedural violations must be raised on the record during the fair hearing, or you can lose the chance to raise them later on additional appeals. You've appealed your MCO decision on PCA services because they are reducing, terminating, or denying your service. But you can also raise issues with the way they went through the process. Even if the MCO thinks they're right, they can't take away or reduce services unless they do it in a fair and lawful way. The rules exist to protect people from sudden or unfair loss of care. It's all about the procedure they must follow. Examples of procedural violations include the inadequate or unlawful notice of action that Gwen discussed earlier in this presentation. It could also be an improper effective date, hearing delays that cause or create harm, a lack of interpreter services available to you, failure to provide reasonable accommodations, not only in the courtroom, but throughout the entire appeals process, problems with the evidence packet, if there's documents missing or things that you didn't receive, or if the MCO applied the wrong standard. One more key point, fair hearings on MCO and DMOS decisions are de novo. That is a legal term of art to mean that the ALJ is not limited to answering the question, was the MCO reasonable? Instead, the ALJ or the administrative law judge can review all of the information fresh and make an independent determination on what that member is entitled to at the time of the hearing. So you can present new evidence during the hearing. Preparation can make or break these cases. Moving to the next slide, we are going to review some key steps to prepare for the fair hearing. The first thing you want to do is review the decision carefully, the appeal and the notice of resolution carefully, and prepare targeted information that directly answers the stated rationale for the reduction or termination. Gwen mentioned earlier that sometimes you will see that it will say, you don't need assistance with bathing because you don't need assistance with bathing. What you will do then is gather documentation to counter that point about the necessary assistance with bathing tasks or skills. In personal care assistance cases, documentation can also include a 24-hour inventory of the tasks or assistance required, provider orders, and a strong letter or a statement of medical necessity from a provider or an expert or a caretaker. You should also request the fair hearing packet from the MCO early. And if you took Gwen's advice before you even finished the internal appeals stage, you will have had a chance to review the entire case file. You want to make sure that you have that information so that you can look for or discover if there are any missing records and request those from the MCO as well. With your right to review the entire case file before or during a hearing, just note that that can be a voluminous file. It might take quite a bit for you to get through everything, but you still have a right to review it all. And we encourage you to utilize that process because we want to make sure that the ALJ has all of the information they need to make an appropriate decision. In addition, we recommend preparing opening remarks and closing remarks ahead of time. Sometimes these are known as opening statements and closing statements. Openings help really frame the case as a healthcare and safety issue while giving the ALJ a brief overview of the care assistance needs. It helps to remind the ALJ that they are making an individualized decision for a human being, not just accepting the formula printout from one universal but not totally accessible assessment tool. And lastly, prepare your witnesses in advance. This could include a potential parent, partner, or caregiver, treating providers if they're available, and anyone who can credibly explain why the requested hours are medically necessary and what would happen if they were to be reduced. Next slide. Once you've gone through the fair hearing process, there are some additional steps. Sometimes the ALJ will allow additional submissions. These could be extra documents or even briefs, which are writings. This is an opportunity to clarify medical need, address legal standards, and respond to any arguments raised by the MCO. And then the ALJ issues what's called an initial agency decision, or IAD. It is then sent to DMAS for review. At that point, both parties can file something called exceptions. Exceptions are basically objections arguing that the initial agency decision is wrong in some way. And DMAS will read those exceptions and the initial agency decision, and they will issue a final agency decision, or FAD. That becomes the agency's final position unless it's appealed further. Next slide. I want to pause here before moving on to further appeals and introduce an important newer protection from our utilization management memo from 2025. Because DMAS acknowledged that they've seen a pattern where members win, the MCO reassesses, reduces services again shortly afterwards, and that effectively wipes out the win, they've created new guidance. So under this updated guidance, when there is a successful appeal that overturns a reduction or termination, and then the MCO reassesses and issues a new reduction within a 5-year period, the MCO must do more than just repeat the same reasoning. If there was no adverse determination in between the successful appeal and the new reassessment, then the new adverse determination must do the following things. It must refer to the prior overturned outcome. It must clearly explain what's changed since that overturned outcome, like the member's condition or living arrangements. And finally, it must justify why reductions or terminations are warranted now. This is specifically tied to that updated utilization management guidance and the contract language. So it's a powerful tool that you have for individuals pushing back against repeat denials that are just basically rebranded versions of the old one. Next slide. Back to our appeals process. If the final agency decision is adverse, the individual may still have the right to appeal to the appellate division. Under New Jersey law, that appeal must be filed within 45 days of receiving the final agency decision. The way an appellate judge will review the case has a different standard than the ALJ at Office of Administrative Law and DMAS. The appellate division generally reviews agency decisions under a deferential standard. They're looking for clear error, and they typically give final agency decisions substantial weight. Remember earlier when I said you must raise any procedural violations at the fair hearing level? This is because if you do need to appeal the final agency decision, you cannot introduce new evidence or raise any violations that you didn't talk about or argue at the fair hearing level. Though I would never rely on this wholly, we do want to point out that the mere fact of filing or preparing an appeal of the final agency decision can sometimes create settlement pressure because continued litigation costs the MCO more, especially when the record shows strong due process issues, weak medical justification, or inconsistent decision-making. So even though this step is difficult, it does remain an option to you, particularly in cases involving serious harm, unlawful process, or systemic issues. And Gwen, I believe that covers the Medicaid fair hearing process and the appellate division process. And so at this time, I'd like to take any questions that anyone might have that we can answer.
Bren, do you have a question for us?
Yeah, so there's one question. What if the state agency continues to try to take away specific orders by the appellate division? Does DDS or another agency have to follow the appellate decisions?
Regina, did you want to take that or you want me to take that?
Go ahead, Gwen.
So I feel like this question is about a particular situation, and if you have a particular situation, it's probably good to go through intake so we can look at the the real specifics as opposed, but generally speaking, if the appellate division issues a decision, then the agency has to follow it. A lot of times in these cases, the decision is to send it back to the agency to uh, to adjust their decision consistent with what the appellate division says. And if that didn't happen, um, I would be surprised if that didn't happen. And if it didn't happen, further legal action would have to take place, going back to the appellate division. So that really is something for an attorney. I also see there's a question about getting copies of the slides. Yes, you will get copies of the slides as well as the transcript. I believe we gave that out last week. And then
Did,
somebody
yeah.
did ask questions about accessibility, format, language access, access for people with disabilities, and I put some answers in the chat around that already.
And there's another one. Do these appeal rights apply to people who self-direct PCA services through PPP?
Yeah, that's a great question. So we talked about the PPP program last week, and we touched a little bit about on the right to have an administrative appeal if your access to the PPP program is cut off. And so sort of to clarify on that, for somebody on PPP, if the action's being taken by the managed care organization, so it's either a denial of eligibility, they don't meet the criteria, the needing moderate uh, assistance in one ADL or minimal in three, um, or if it's an issue related to the denial, reduction, termination of hours, then that would be everything we talked about today. That action is against the managed care organization. Under the regulations for PPP, the Medicaid agency has sole discretion about whether or not somebody can self-direct, either to get in to PPP or to remain in PPP. And that is a little less clear in the regulations. It says they have the right to an administrative appeal first to the agency. We did reach out to Medicaid on this to get clarity, and they wrote back and said some guidance is coming that will clarify that for people who are on full scope Medicaid, Medicaid Plan A, yeah, they will have access to a Medicaid fair hearing process. There wouldn't be an internal MCO appeal first there because it wouldn't be against the MCO. So hopefully that answered that question.
And then there is a question, does this, and I believe that this is referring to appeal rights, pertain to PASP as well? And that's Personal Assistance Service Program.
Yeah, great question. We got questions about PASP last week as well. And those are state services, state dollar services. They are not Medicaid services. And so all the things we said last week and this week don't necessarily apply to that program. Some of it might apply. And I think what this tells me is we have to do a webinar on PASP because there's been a lot of questions. So stay tuned. Hopefully we can get one soon. And if you have a specific question about your own PASP benefits, do feel free to call our intake. And I think the slides at the end of this have the information on that.
And that looks like the rest of the questions in the chat. I know, Gwen, you answered some pertaining to accessibility previously, and we probably have time for one more if anybody does have any remaining questions.
While we wait on that, I'll just go back because somebody asked me a question about could you substitute a virtual hearing, like a Teams meeting or a Zoom meeting for the in-person hearing? And I think that's a great idea. I put in the chat, I've only actually had requested an in-person hearing once. They didn't believe me that it was a right. I had to show them the law. I had actually show them where it said in the contract how to do it. And it's settled because that costs the MCO a lot more money to go to that, and so they settled. So I've never actually done it, and so you all can try it and let us know if it works. And I can imagine that an MCO would be amenable to having it by Zoom rather than in person because it's more cost effective for them.
Yeah, and Gwen, I will say that each administrative law judge operates their room a little bit different, their courtroom a little bit differently. And so sometimes making that request, they might ask you the reason that you require it to be on Zoom or in person. And just as a reminder, you have an inherent right to be able to see the people that are making a decision about your services or the services of someone that you're caring for. But that if you do have a medical reason for it to be over Zoom instead of in person, or an accommodation that you require and you are comfortable disclosing that, you can do it at that time. But we have seen pushback from some judges who aren't as comfortable with technology as others.
So I think what we're saying is the Zoom option could apply both to the internal MCO level and the fair hearing level, but there's different considerations and there are rights that you want to think about before you give up your right to an in-person anything.
Yeah.
All right. It looks like that is the end of the question. So thank you all for joining us this afternoon. Please, we'll get this out, share it around. Now we have both part one and part two done. That's sort of the centerpiece of our self-advocacy resources, but we've got some more coming, including this checklist related to the memo. So keep an eye out on our website, and everybody please stay warm and dry and safe this weekend in the big, big snowstorm or ice storm or rain, because we never know here in New Jersey. Take care, everyone. Have a good afternoon. Bye-bye.